Well, let's ask Kristen. You use this 6312 in the Trump University suit, a university that was scamming people, wasn't actually giving them useful information for them to do business,
and wasn't licensed and wasn't a university, et cetera. Yes.
Yeah. So tell me, is it fair?
Look, the thing is that the notion that 6312 is this sort of weird thing that shouldn't be applied and so forth and so on, this statute and the statute that was based on, which is called the Martin Act, which may be the one that people are more familiar with, the Martin Act applies to securities. The Martin Act was put on the books in New York about 100 years ago. We have a lot of case law to support this. This statute is used by the AG's office every day against all sorts of other frauds and misdeeds. The legal standard is whether there was a tendency to deceive. That's what it is. And the legislature in New York made a public policy choice to say that that was an important weapon for the AG's office to have to vindicate the public good in this situation.
And it seems like what Judge Engoron found was there was intention, not just a tendency, there was intention to deceive.
Which is even higher than they needed. It's basically if the bar is here, the evidence went way over the bar.
I mean, he's saying when confronted at trial with statements, defendants' fact and expert witnesses simply denied reality, and defendants failed to accept responsibility or to impose internal controls to prevent future recurrences.
Under 6312, you don't need intent, but intent becomes an aggravating factor. So that's part of why we see the penalties so high here. There's a couple things. One is there was a great graphic that was up just a second ago, and it showed especially Seven Springs, I think it was one of them, where let's just talk about the numbers here. The sheer quantity of the disparity between what he claimed the property was and what it was appraised for. We're not talking about something where he rounded up a little bit or added a little 10, 20%, 30%. That one right there. That's the one. Take a look at that. Look at Seven Springs, $30 million appraised value, and he tried to value it at, my eyesight is terrible,
$291
to $291 million. You got to be kidding me. Just that is it right there. Screenshot that. That's your exhibit A right there. For if you want to know why is he in this much trouble, that's why.
So he
tried to give a 10x premium over reality.
Let me hold on, guys. Let me read from specifically the piece in this ruling on Seven Springs. I happen to have it in front of me. From 2011 to 2014, when valuing a plot of land upon which 7 mansions could be built in Bedford, McConney relied on valuations provided by Eric Trump, who advised McConney to value the 7 mansions development at $161 million on the 2012 SFC, which is a financial statement. This valuation assumed a host of future events that had not, and as hindsight has shown, would not occur, including that the Trump organization had received legal permission to develop the lots, that the mansions were already built and available for sale, and that there would be no construction or development costs associated with building the mansions. Eric Trump further advised McConney to use these values again in 2013 and 2014. Eric Trump was aware that the values he was providing would be used on his father's SFCs. Upon realizing that building the 7 mansions would be neither feasible nor profitable, the Trump organization, through outside counsel, Sherry Dillon, commissioned an appraisal from the Cushman & Wakefield firm to determine the value of the development rights for the plot of land upon which the Trump organization had previously considered building the 7 mansions. In August 2013, Eric Trump advised McConney to continue to use the undisclosed value, undiscounted value of $161 million for the 7 mansion development, despite having received an initial estimate approximately $5.5 million from Cushman & Wakefield. And it goes on, this is just one little portion further. On September 8, 2014, David McCardle of Cushman & Wakefield advised Eric Trump verbally that he had appraised the 7 mansion development at $14 million. Notwithstanding, a mere 4 days later, Eric Trump advised McConney to continue using the $161 million value. So on September 8th, he was told it's $14 million. 4 days later, September 12th, he advised McConney to continue using the $161 million value. So from $14 million to $161, underscoring your point.
Right. So that's number one. Number two, if we're then going back to talking about the bans or the cancellation of the corporate charters, which now is out of the punishment here, whereas before it had been in. There is one thing that I want to point to when we're talking about harm, is that what should be looked at here, I think the AG's office should really be looking at this. I hope it's something that we see on in further arguments in this case, and that on appeal, is that we should not just be looking at the fraud and illegality that was committed in this particular case. When 6312 has been used before to bring about these kind of removal of licenses or banning from industries and so forth and so on, it is to look at the totality of that bad actor's misconduct in New York State. So in my view, we should be looking at Trump University. We should be looking at the Trump Foundation. We should be looking at the Manhattan.
The foundation, which was ordered not to
they had to wipe it out because it was stealing money from a kid, from money that was supposed to go to kids' cancer charities. You had the Manhattan DA, we forget about this case now, got a conviction of the Trump Organization, what was a year or two ago, for tax fraud with regard to executive compensation, and that also applied to Alan Weisselberg, and he spent some time in Rikers for it. And then the violation of the court order in this matter itself, where he took $40 million that was supposed to not be moved out of the Trump Organization and used it improperly for his personal expenses. All of this adds up to just I'm colloquializing here, but it's criming, the criming.
There's going to be a lot of gems in this.